Well, let me welcome all of you to part 2 of the Jurisprudence of Clarence Thomas, 25 years on the court. For those of you just joining us, my name is Michael Pack. I'm president of the Claremont Institute and publisher of the Claremont Review of Books. And we have copies, I think, at the side table and in the back. Once again, I'd like to thank Dean Reuter and the Federalist Society for co-sponsoring this event. Thank you. I think Dean is here. Thank you very much. In introducing this panel, let me cite a comment of Abraham Lincoln that he made about the Declaration of the Constitution, referring back to an old proverb in the Old Testament. He described the Declaration as an apple of gold and the Constitution as the frame of silver around it. The constitutional frame is made to fit the apple, Lincoln wrote, not the other way around. And by this, of course, Lincoln meant that we cannot fully understand the Constitution without first understanding the principles of nature and nature's God underlying the Constitution and cited in the Declaration of Independence. So the next panel will explore Justice Thomas's judicial approach with regard to upholding the Declaration of Independence's role in providing a philosophical foundation for the Constitution. And I think there's a range of views on this panel. We're going to try to keep the comments relatively short so there can be discussions within the panel and then with the audience. Let me introduce the panelists for this session, starting from left and going right. To my immediate left is John Eastman, who is the founding director of the Claremont Institute's Center for Constitutional Jurisprudence, as well as senior fellow at the Claremont Institute. John Eastman also serves as the Henry Salvatore Professor of Law and Community Service at Chapman University's School of Law. From 1996 to 97, he served as law clerk for the Honorable Justice Clarence Thomas. To John's left is Ken Masugi, a member of the faculty at Johns Hopkins University. He is also a senior fellow with the Claremont Institute. Previously, Ken served as a special assistant to the then chairman of the Equal Opportunity Employment Commission, Clarence Thomas. Next, we have John Baker, who has been a visiting professor at Georgetown Law School and is currently a visiting professor at the Peking University School of Transnational Law. And he is professor emeritus of law at Louisiana State University Law School. Prior to Justice Scalia's passing, John co-taught courses with the Justice for the Federalist Society on separation of powers. Last, we have Roger Pilon, who is currently the Vice President for Legal Affairs at the Cato Institute. He is founding director of Cato's Center for Constitutional Studies and founding publisher of the Cato Supreme Court Review. Prior to joining Cato, Roger held 5 senior posts in the Reagan administration, including at State and Justice, and was a national fellow at Stanford's Hoover Institution. So with that, I'm going to ask John Eastman to begin. Thank you.
Thanks, Michael. It's a real pleasure to be here, particularly in this grand room, to talk about the constitutional interpretation, particularly the natural rights foundation or the natural law foundation of Justice Thomas's jurisprudence. You heard a little bit on the earlier panel about how that played out in some certain cases. I want to try and articulate the fight a little bit differently. And it's about the role of the Declaration of Independence in informing the justices' view of originalism, original meaning. This most famously came out in a playful clash between Justice Thomas and Justice Scalia over a number of years and over a number of opinions. I think most pronounced by Justice Scalia's rejection in the grandparents' rights case, Troxel, of the right of parents, the fundamental right of parents to direct the upbringing of their children, a right nowhere mentioned in the Constitution or the Bill of Rights, and yet it's been with us as foundational ever since the cases articulating that right were decided in the 1920s. Justice Scalia accepts the view that the Declaration of Independence recognizes the inalienable rights, but he doesn't think that his role as a judge allows him to define what those are and certainly not enforce them. Justice Thomas has a different view. He expresses it there, but he expresses it most succinctly in a federal contracting affirmative action case. He said, this violates the fundamental principle of equality that inheres in our Constitution. And the citation for that, of course, there's no equality clause that applies to the federal government in the Constitution as a textual matter. That only exists in the 14th Amendment, was a limitation on states. And nevertheless, he says boldly and quite confidently, this violates the principle of equality that inheres in our Constitution. And his sole citation for that, see Declaration of Independence, paragraph 2. Or see what I mean, Justice Scalia. You can read that in that. Now, we also heard a lot earlier about the Mcdonnell versus City of Chicago case. And I think the historical case for Justice Thomas's concurring opinion on that is compelling, as you heard on the earlier panel, that it's privileges and immunities. But it's not just compelling because it's historically accurate. It's compelling because it taps into the underlying theory of the Constitution. He doesn't say it's only because of that history and only because of the conversations that Bingham and Howard had on the floor of the Senate and the conversations that were part of the ratification, although that was certainly part of it. He says, the 14th Amendment's Privileges and Immunities Clause was designed to repair the damage that slavery had caused to our body politic because it was irreconcilable with the principles of equality, of consent, of inalienable rights. And again, all three of those don't exist in the Constitution. They're all things articulated in the Declaration of Independence, proclaimed in the Declaration and embedded in our constitutional structure. And so he looks at this history of the Privileges and Immunities Clause and the debate, but it's always against the backdrop of the philosophical foundation that's bequeathed to us in the Declaration of Independence, that natural law foundation. And in fact, every one of his landmark decisions, there's a twit out this morning on New Yorker saying that Justice Thomas has never published a landmark opinion anywhere, and it's because Chief Justice Rehnquist and Justice Roberts can't trust him to carry a majority. You know, I hope Jeffrey Toobin's piece is still recalled when the papers of Chief Justice Rehnquist are made available to the public so that he can see what all of us that have been at the court know, that more than any other justice, he gains votes after initial opinions circulate rather than loses votes. He is, and Toobin recognizes this later in his own ridiculous article. He says, Justice Thomas is moving the court to the right. Well, if he has no influence, how can that possibly be true? Anyway, I lay this out because the markers that he is laying are tapping into a deeper foundational philosophical root of our regime than the kind of mere positivism that is often described conservatism for the last 50 years. And if we're going to fight back against this notion that the Constitution doesn't mean what it says, against what is really a DNA in the American people, this idea, this deep-rooted idea that there are fundamental rights that mere positive law can't trample, that the rule of the majority can't infringe. This merging of consent of the governed, which leads to majority rule, and foundational inalienable rights, which leads to an independent judiciary that would say no even to a majority. That blending, that balance that is there in the Declaration of Independence has to be properly understood to get our constitutional interpretation right. And I think Justice Thomas, more than any other justice, perhaps since Joseph Story, has got that grasp of the Constitution. So when President Bush said this is the best nominee for the court back in 1991, it really was true. Now, how will this play out? I'm often asked, how does this idea of natural law versus the more positivism, originalism play out? Let me give a suggestion on how it might play out in an upcoming case and the difference that this philosophical outlook on constitutional interpretation might have. We've got a lot of these felon voting cases working their way up to the Supreme Court right now. I don't know when they'll get there, and I don't know what the court's going to look like. But I have no doubt that someone will argue that the Equal Protection Clause of the 14th Amendment or the equal protection idea in the Due Process Clause of the Fifth Amendment, which applies to the federal government, will somehow give rise to the challenge that the denial of felon voting violates equal protection. The positivist originalist response would be, well, Section 2 of the 14th Amendment specifically recognizes that states can deny voting to folks committed of a crime without losing their representation, and therefore that's implied that there's this ability to limit voting for felons in the 14th Amendment, this kind of textual response. But textual responses to fundamental rights never have prevailed in our psyche, in our body politic. The natural law response would be something like this. that the idea of felon voting is contradicted if you look back at the reason why felons were disenfranchised in the first place. It's contradicted by the very idea of Republican government and consent. Those that have committed serious felonies against the body politic have rejected the notion that government is based on consent. And they've participated in the violation of fundamental and inalienable rights of others. And by so doing, they have eschewed the very thing on which they are basing their claim of equal right, this very fundamental right. And it's for that reason we have excluded them from continuing participation in the body politic until they demonstrate that they ought to have those civil rights restored. That's a completely different originalist understanding of the opposition to some claim of felon voting rights. And I think you may well see it play out. But I think it's very telling that the markers that Justice Thomas has been laying all along the way in his 25 years almost inevitably are rooted in this philosophic understanding of constitutional interpretation, the ideas that are articulated in the Declaration, and as he says, and therefore embedded in the Constitution. Thanks very much.
The two national politicians who have made the most of the Declaration of Independence recently are President Obama and Clarence Thomas. They have opposed views. See Obama's second inaugural. The former President Obama, as we know from his both his writing and his practice, would make the Declaration an unlimited empowerment. You could call it, to steal a phrase, progressive originalism. Whereas Clarence Thomas is an originalist, and he uses the Declaration and the Constitution to control and limit governmental power. Adam White has done some interesting articles on Thomas's earlier writings and their relationship to his current jurisprudence. And Clarence Thomas's own very recent thoughts, as well as those in his autobiography. You can look at the Bill Kristol conversations to see some of his own reflections on how his thinking evolved. Well, how do you relate the Declaration and the Constitution? And I think you do this by raising the question of what Republican government means. Republican government, we can reflect on the Federalist Papers, their explication of Republican government, republicanism, is a form of government that's fundamentally opposed to the administrative state. The administrative state is not merely some corruption of separation of powers, although that's certainly a great part of it, but it's a different form of government. It's a different type of regime. That's the way it needs to be attacked, and that means we need to go back to fundamental questions of natural law and natural rights and the meaning of the form of government that can come out of it. Otherwise, we may wind up adopting progressive originalism. Justice Thomas raises these fundamental questions in an opinion from April of this year, in the last term, Evanwell v. Abbott, which was a case unanimously decided about Texas's apportionment views. But I'm going to just focus on a few pages he spends on the Republican Guarantee Clause. Well, anyone who's taken a course in constitutional law knows that Luther v. Borden, this pre-Civil War opinion back in the 1840s, dismissed it as a political question, and the author of that opinion was none other than Roger Taney. And indeed, there is a connection between the Taney of Luther v. Borden and the political question and the Chief Justice Taney of Dred Scott. And it's both Luther v. Borden and Dred Scott are embarked on the mission of destroying the Declaration of Independence as a foundation for positive law. Because what Tawney does in Luther v. Borden is to turn the definition of Republican government into a mere political question. And that's a dubious enough notion, the political question notion. But when you unmoor it from the Declaration of Independence, then the meaning of Republican government becomes very subjective. Now, Justice Thomas says in his portion of his short concurring opinion, quote, "None of the Reconstruction amendments changed the original understanding of Republican government. None of the Reconstruction amendments changed the original understanding of Republican government." Now, my esteemed colleague here, John, has gone over privileges and immunities in the Mcdonnell case. I'm going to go over something, kind of a friendly amendment, I suppose, and back away a bit and argue that, or assert in a brief time here, that the 13th Amendment restored the original understanding of the Constitution. And the 13th Amendment is not simply a no to slavery, but there's implicit in it an enormous negative pregnant about what it means to be free, not simply abolishing slavery, but what it means to be free. And the 13th Amendment alters the entire document of the Constitution. So I think it affects apportionment, the 3/5 clause, fugitive slave clause, of course, privileges and immunities, and the Republican Guarantee Clause, because as we know from reading the Federalist or being casually informed about history, there are all kinds of republics possible, oligarchic republics, aristocratic republics, much more popular ones, democratic republics. And what the 13th Amendment does for us is to prohibit slaveholder republics. That's a form of republicanism that's gone. And so that's why I think Thomas cites Federalist 43, which is the most explicit direct reference to the Federalist in the Declaration. And I would pair Thomas's revival of the Republican Guarantee Clause here with Justice Harlan's famous colorblind Constitution dissent in Plessy v. Ferguson. He concludes his dissent there with an explicit reference to the Republican Guarantee Clause. And so you see the relationship. And finally, given the popularity of the musical Hamilton, I thought I would not sing any of that, but to just read very briefly from the end of Federalist 11, which is also a great reference to the Declaration. And here Hamilton talks about American greatness, and he bemoans the European domination of the world. Africa, Asia, and America have successively felt her domination. The superiority she has long maintained has tempted her to plume herself as the mistress of the world and to consider the rest of mankind as created for her benefit. Facts have too long supported these arrogant pretensions of the European. I skipped a very interesting passage here. It belongs to us to vindicate the honor of the human race and to teach that assuming brother moderation. I guess Europe here is a hermaphrodite because first she was a mistress and now she's a brother. Union will enable us to do it. Disunion will add another victim to his triumphs. Let Americans disdain to be the instruments of European greatness. So this is Hamilton's call for American greatness. Africa, Asia, America will stand up to Europe. And that means, for us today, Europeanized elites.
We hold these truths. To hold is to believe deeply. They could probably still hear me anyway. To believe deeply. Truths, to hold truths, means to recognize realities that bind our individual wills and that bind the collective will of the state. Not many people in office today talk about truth, except maybe on the 4th of July when they're reading the Declaration. They would be more comfortable today by saying, quote, "We have these values." Not quite the same ring to it, but what it would do is to make moral relativists feel less uncomfortable. What Justice Thomas really does, even more than Justice Scalia, is to make moral relativists feel very uncomfortable. He rattles them. My job here is to compare Justice Scalia and Justice Thomas, where they agreed and where they disagreed on this question of the Declaration and the Constitution. To do that, I want to make 3 points. First, the Constitution instantiates the natural law expressed in the Declaration. Ken has just read some from the Federalist, which confirms that. 2, the status of the Declaration as, quote, law, or as part of, quote, constitutionalism, really depends upon the meaning of those 2 words. 3, in the end, I assert that both justices do natural law, but in rather different ways. So on the first point, remember that Justice Scalia in Obergefell said, "The Declaration gave us our most important right, the right to govern ourselves." It's not that he ignored the Declaration. There are a whole series of cases in which he cites it. I want to explain the framework, the structure, I think, as he largely viewed it, and point out that I don't think that the division is as radical as some people think it is. First of all, there is always a problem in natural law philosophy in moving from the general principles to the more specific. Take, for instance, the concept of due process. That's not just an Anglo-American concept. It's a concept that applies worldwide. It should bind every nation. But due process varies from country to country depending upon their own particular methodology and history and procedure. We look at jury trial as being fundamental. The French don't. Does that mean they violate due process by not giving jury trials in criminal cases? No. It means something more fundamental, beyond the specific rule. Well, with due process and the Anglo-American experience, we have a particularized history. And for the British, the common law embodied the natural law. But it was a mixture of many things in their culture and history that we came to value as historical rights that were the rights of Englishmen. They were not the abstract rights of the French Declaration. Very different thing, a very different approach. And although my friend Roger here is going to tell us that the Declaration is this Lockean document, I would just read from Jefferson's letter to Henry Lee in 1825 and saying, we're not saying anything new or novel. This is what everybody agrees on, citing Aristotle and Cicero and Locke and Sidney, etc. That is, it was a great tradition of natural law. There are big differences, and Roger will be right to point these out. But as the great constitutional historian Forrest Mcdonnell has pointed out, the founders were not philosophers. They were philosophic men, and they often got a lot of things lumped together that really shouldn't be lumped together, and they created inconsistencies. But we'll hear more about that from Roger. Out of our Declaration came two different governing documents. First, the Articles of Confederation. That's consistent with the Declaration and the Constitution, but the two are not consistent. Does that mean that you somehow can go up to the Declaration and over to the Articles and import it back in? No, obviously not. The particular governing documents are what govern us more specifically than the more general principles of the Declaration. That doesn't mean a denial of the protections, but when it comes to jury trial, we don't go to the Due Process Clause first, we go to jury trial. The second point in terms of the Declaration as law or constitutionalism. In the matter of interpretation, Justice Scalia famously said, "There is no such philosophizing in our Constitution, which, unlike the Declaration of Independence and the Declaration of the Rights of Man, is a practical and pragmatic charter of government." Now, he's not being radical in that. Chief Justice Marshall and Justice Story said that a number of times. There is a difference between the general principles and the specific law. The question will then come down to, what do you mean by natural law, positive law? Is it natural law to declare positive law? Does that make it positivism? Or is it really natural law-backed positive law? That's beyond the scope of this 5 or 6 minutes. Constitutionalism, as a word, doesn't mean just what our Constitution says, that it's the supreme law of the land. We're the first one to say a written Constitution is the supreme law of the land. Constitutions have been around since the beginning of political bodies. Read Aristotle. So when you say constitutionalism, there is no doubt that the Declaration does the most important thing. It creates one people, without which we never would have had a Constitution in the first place. Last point, and I'm running out of time, so this will be brief. Both do natural law. There's two forms of natural law. One is the substantive and the other is the procedural. The jury trial, although few lawyers know this, is really Aristotle's rhetoric made practical. The problem for philosophers always is, how do you turn the natural law into something that produces justice? That's what our Constitution was all about. Justice Scalia, although he probably didn't recognize it, in his argument, because his argument was always ends-seeking, it was not the policy stuff, it was not the consequentialism stuff, presumed that there was a truth behind it. Justice Thomas is much more the historical scholar. Justice Scalia was much more the rhetorical persuader. Both are very important, but ultimately they're the same in this. The definition by Thomas Aquinas of law is a rule of reason laid down by the person who has responsibility for the community, for the common good, and promulgated. If, as we all do, and most Americans do, the Constitution is legitimate because, as in the preamble, it states that very purpose, then the question is, what is the role of each of the particular branches and the authority that they have been given under the Constitution? Justice Scalia and Justice Thomas had slightly different views on this. But it's important for us to celebrate that because, after all, the opponents of originalism are always portraying it as wooden-headed, as if somehow it is cranked out and there's an automatic answer. The differences between the two justices are good testament to the fact that it really does involve, first of all, truth, a commitment to the Constitution, and then the fallible reason of even great men. Thank you.
Well, I want to thank John Baker not only for anticipating my remarks, but for
read your
affording me a material to which to respond. We were instructed to keep our remarks to 5 minutes. Owing to the prolixity of my fellow colleagues, I am, as someone recently said, unshackled. And I will try to keep myself to a reasonable amount of time, unlike the person who used the word unshackled. But in any event, I digress. The topic for this panel is the Declaration as the central idea in American constitutionalism. And John has also afforded me a segue by talking about both Thomas and Scalia to a case that I want to focus on by way of contrasting the two, namely Troxel v. Granville, which John Eastman only mentioned, and I will discuss a little more fully. But before I do that, I want to lay a proper foundation for our topic. The contrast between Thomas and Scalia with respect to the Declaration is stark in many respects. There is no justice, probably in the history of the court, who has had greater respect for the Declaration than Thomas has. Scalia, by contrast, has called the Declaration, and indeed the preamble to the Constitution, aspirational, in contrast to the operative provisions of the Constitution itself. And I am here to submit that he is dead wrong on that. It is aspirational, to be sure, but it is also substantive, the Declaration and the preamble for that matter. Indeed, we find the Declaration as 1 U.S. stats for those who think that it is not law, as Justice Scalia has said. The Declaration is, of course, where the founders, set forth their philosophy of government that 11 years later they incorporated and institutionalized to a great extent in the Constitution. And that philosophy of government draws from the natural law tradition that stems from antiquity. And in that tradition, we have an appeal to a higher law of right and wrong from which to derive the positive law and against which to criticize that positive law at any point in time. And there's nothing extraordinary in that idea. It's what we all appeal to when the positive law is wrong. It's what the abolitionists appeal to as against slavery, the suffragettes in their effort to get the franchise for women, the civil rights movement in their effort to overturn Jim Crow. And so what you do is, with that idea of what the natural law, higher law, or the natural rights strain, which is what indeed the founders drew upon in the 17th and 18th post-Enlightenment context, with that context in mind, one looks at the Declaration and you see that Jefferson divided that famous second paragraph into two parts. He set forth the moral order first, and then the political and legal order that is derived from that moral order. And the moral order starts with the premise of equality, and it defines it with reference to rights to life, liberty, and the pursuit of happiness. Rights, not virtues, not values, but rights, which are very different moral notions than virtues or values. And that notion of a right to pursue happiness has implicit a distinction between rights and values, such that we have objectivity with respect to rights by implication and subjectivity with respect to values, such that we now have morality on one hand that we can get hold of as against the moral skeptic with respect to our rights and correlative obligations, and we have liberty on the other hand with respect to how we can exercise those rights as against the moral dogmatists. And so we have, as it were, the best of both worlds with that distinction between rights and values, which is at the heart of the vision of the classical liberals. And then only when he has explicated that, in outline at least, and indeed drew in large part by implication, as John Baker just said, with the common law, do we turn to government. And as we see, government is twice limited by its ends to secure our rights and by its means which must be consented to. But that consent requirement is extraordinarily difficult to overcome, which means it devolves into majoritarianism, which leaves us with an unfortunate conclusion, namely, not unfortunate, actually is quite fortunate, namely that there is an air of illegitimacy that surrounds government as such, as distinct from private associations, because due to majoritarianism, the minority does not consent. And once you recognize that air of illegitimacy that surrounds government as such, it is a necessary evil. You can think of a continuum, starting down here at anarchism, the absence of government, up here totalitarianism, total government, and each step along the way as you move up with more and more government, you will find consent falling off until you get up here, nothing is consented to. This is totalitarianism. And so now you have your framework to think about legitimacy, which is what the Declaration of Independence is all about. The idea is that as you work your way further up this continuum, you will have less and less legitimacy. So it behooves you to do as little as necessary through government and as much as possible in the private sector where it can be done voluntarily and hence in violation of the rights of no one. There is essentially your theory of legitimacy that stands behind the Declaration and that the framers took with them 11 years later when they drafted the Constitution. And in the preamble, you can see this borne out. All power starts with the people. They create the government. They give it such powers as they do. The government does not give the people their rights. They already have their rights, their natural rights. And so now we're often running with the government that is instituted and authorized and empowered by the people. And we see it spelled out with the doctrine of enumerated powers, with the provision, as the 9th and 10th Amendments make clear, that we all have rights, both enumerated and unenumerated, whereas the federal government has only those powers that are enumerated in the document. It wasn't perfect, to be sure. There was the oblique recognition of slavery, and finally the Civil War, which ended it in the passage of the Civil War amendments, which provided for the first time federal remedies against state violations of our rights. It can be seen as having completed the Constitution by incorporating the grand principles of the Declaration. And so now we have, with the completion of the Constitution, the Declaration and the Constitution conjoined. Let's now move to the issue of the contrast between Thomas and Scalia, starting first on powers and very briefly, and then on rights. Greg Katz gave us a good discussion of the difference between the two on the power side with respect to Lopez, Morrison, NFIB, and with respect to the Raich case, the California medical marijuana case. The one point I want to bring out here is this, namely that Thomas, in effect, in his concurrence, said to William Rehnquist, if the framers had wanted to say that commerce had the power to regulate anything that substantially affects interstate commerce, they could have. They didn't say that. And that captures in a nutshell his view of the doctrine of enumerated powers. On the right side, I'm going to go to Troxel. Troxel was a case that challenged the grandparent visitation statute that had come out of the state of Washington that authorized grandparents and others to go into federal court or to state court to get an order to allow them to visit the children of parents who may not have wanted those people to visit their children. So it raised the fundamental question, is there a fundamental right of fit parents to control access to their children? The Supreme Court of Washington found under the Due Process Clause of the 14th Amendment that there was such a right, and the U.S. Supreme Court upheld that. Scalia dissented, and in his dissent, he said that the right of fit parents to control access to their children is one of the inalienable rights that the Declaration of Independence speaks of, and one of the unenumerated rights the Ninth Amendment refers to. But he said the Ninth Amendment does not authorize him to say what those rights are, much less to enforce them. Well, you see the problem he's got right immediately. He's called it an unenumerated right under the Ninth Amendment. He's called it a constitutional right. It is the duty of the courts to defend constitutional rights, but he said he's not going to say what those rights are. He's going to leave it to the states. Well, the states spoke to that issue, and they said there is not a constitutional right of fit parents to control access to the children. So you see the problem. On one hand, he says it's a constitutional right. On the other hand, he leaves it to the states to say it's not a constitutional right. He wouldn't do that with enumerated rights. He should not do it with unenumerated rights. If he is an originalist, indeed a textualist, it falls to him to say what the law is. He cannot ignore the plain text of the Ninth Amendment or the Privileges or Immunities Clause of the 14th Amendment, through which the Ninth Amendment is incorporated against the states with respect to unenumerated rights. And so we come to that fundamental distinction between the two. Thomas had it right in his very brief concurrence in the Troxel case when he said that this is an unenumerated right. He said that this is a fundamental right, and therefore it falls to the court to ask whether what the interest of the state is. The court held that not under strict scrutiny, but rather under a lesser standard, that that there was no harm, and therefore the statute was overturned. No harm at issue by the Granvilles in prohibiting the visitation. Thomas's point was quite simple. This is a fundamental right. Strict scrutiny is required, and therefore the question is there a legitimate government interest? He said there is no legitimate government interest behind this statute. There certainly isn't a compelling interest. That is the end of the case. And so he approached it correctly by focusing on whether there is a power, which is one of the important ways you go about determining or applying the Ninth Amendment, so that you don't have to ask, is there a right? You ask first, is there a power? If the government cannot come up with any rationale for that, as it hasn't been able to do so in many cases from Lochner to Lawrence, then the government is out of court. Thank you.
Thank you all for a very interesting panel. I sense there are differences in the way you all think of natural law, and I hope that comes out a little more in the question period. As with the last panel, we'll take questions from the audience, and while you're gathering your questions, I'm going to take the privilege of being moderator and ask the first one. And this also may go to my self-interest as president of the Claremont Institute. I'd like to ask John Eastman and Ken Masugi, who worked for Clarence Thomas in different capacities as clerk and at the EEOC, whether they think the Claremont Institute has had a significant influence on Clarence Thomas's thinking, especially in this area of natural law. Maybe.
Okay. You know, I'll let Ken take that up first, because. But I'll introduce it by saying things that Ken may himself be too humble to say. You know, Justice Thomas had a more traditional, non-foundational education. And when he went to law school, he deliberately avoided the kind of study of the things we're talking about now, because that got you into locking you in. He says this, locking me into things where people would tell me I should have a certain view of these things and others. So he went as far away from those questions. He went into corporate law and tax law. He says, I went as far away from those questions as I could get. Well, then he ends up back in Washington, D.C., and this is the first thing everybody wants him to address. And like Socrates, he realized I hadn't studied this and I didn't know it. And so he reached out to people who he thought did know it. And one of the people he reached out to was Ken Masugi. And it was part of the confirmation hearings, it's part of his book. But he reached out to Ken Masugi and John Marini, both senior scholars at the Claremont Institute, because they understood something about the founding of America and the role of the Declaration of Independence that Justice Thomas wanted to learn. And we had wonderful seminars at the EEOC, and Ken, you can describe those.
Well, I'll just say, yeah, that sounds like it, yeah. Look, he was a great teacher of mine, and the finest teacher of government that I've had. We'd go to meetings on the Hill, and afterward we'd evaluate, well, what was going on here. Is always insightful and also extremely funny, a very caustic sense of humor at times. He had good material to work with. So it's out of a kind of, well, I don't know, sort of you sort of sense a kind of Old Testament background here in his personal upbringing. And that gave him an openness to think about political and moral things in their fundamentals. So I think that gave him sort of a natural point of departure for thinking about the most serious questions. And I was very serious when I began my remarks by contrasting Obama and Thomas on the meaning of the Declaration and on the meaning of having to live under arbitrary power and recognizing it for the viciousness that human beings can do to each other, and actually having seen it firsthand, seen its effects, felt its effects. And so that gives his thinking and writing a seriousness which intellectuals lack. I mean, pure intellectuals. I'm not talking about smart people or dumb people or arrogant people, but he has a seriousness about himself that is not always there in those of us who grew up under much more privileged circumstances.
Okay, thank you. Let me take some questions from the audience. We have someone coming around with a microphone, I think. So if you introduce yourself, that's probably helpful.
Trey Mayfield, attorney. To any of the panelists, is Bowling v. Sharp correctly decided? Or put another way, is there an equal protection requirement upon the federal government despite the absence of any direct text to that effect?
Yeah, look, I mean, this goes to the heart, and I want to, in our dispute here, standing in for the dispute between Thomas and Scalia, I don't want to overplay it. I described it as a playful dispute. John Baker's right that because of the textual origins of much of our Constitution being rooted in the English common law, which was itself a search for natural law, there's not a lot of difference. But this is one of the areas of difference. Most recently, in one of the equal protection cases dealing with the federal government, Justice Scalia takes issue with Bowling versus Sharp, and Justice Thomas doesn't. I mean, you get, but it's not because whether it's in the text or, I mean, it's crazy to say we can read it into the text. If equal protection is part of due process in the Fifth Amendment, then all of the rest of the Bill of Rights are redundant because it's the due process clause in the 14th Amendment by which we've incorporated all the Bill of Rights. So as a pure textual matter, it's nonsense. At the deeper level, is the Constitution designed to codify the fundamental principles of the Declaration of Independence: equality, consent, majority rule, and unalienable rights, which also requires that we recognize something that is counter to the majority or counter to consent. Right? Those fundamental aspects of the Declaration are embodied in the different aspects of the Constitution. And I don't think you can fill out or interpret the interstices of the Constitution without understanding that core principle. I think Bowling versus Sharp, despite its flaws and trying to pretend that it's somehow rooted in the text, actually does that at a deeper level.
I'd like to add to that. I think that it is, first of all, Bowling v. Sharp, for those who are non-lawyers, was the decision that held that that was coupled with Brown v. Board of Education, but it would apply to the District of Columbia, and since Brown was decided under the 14th Amendment, which applied only against the states, the question is whether segregated schools could be continued in the District of Columbia. And it seems to me that the answer is clearly the decision was right, even if not necessarily rightly argued. And I think that the very idea of the Equal Protection Clause, which is implicit in the Due Process Clause of the Fifth Amendment, is inherent in government as such, which belongs to all of us, and therefore must treat us all equally unless it has some compelling reason not to do so. And that is the kind of underlying principle that you have to appeal to, which means that segregated schools were wrong ab initio in the District of Columbia, that Plessy v. Ferguson was always wrong, and Brown v. Board of Education plus Bowling corrected those mistakes, even if the arguments that underpinned the decisions were less than principled.
Okay, next question, maybe right here in the middle.
Hi, my name is Devin Watkins. My question for the panel is about the definition of liberty under the Declaration of Independence and the Due Process Clause. Recently, there was a decision on same-sex marriage that said that the definition of liberty allowed or required that government recognize these same-sex marriages. How would you, or do you think these right of liberty under the Due Process Clause, which I assume is the same as the Declaration, should be defined, and should that government recognition of same-sex marriage be included?
At the founding, liberty didn't equal license, and there was a big distinction. So if we go back to the public meaning of the word liberty, it was liberty under law.
Yes, but that opens the Pandora's box for anything that is law can restrict liberty.
But it was higher law. It was
Only
it was
higher
more,
law?
It would, no, but it was moral law. And so a claim of liberty that violated moral law had no place.
So therefore, Lawrence was wrongly decided.
Yes.
Okay, now we've got it on the record, folks. Lawrence v. Texas was the same-sex sodomy case, a challenge to the Texas statute that criminalized same-sex sodomy. The original statute criminalized all sodomy, but the legislators of Texas realized, whoops, that's catching too many of us, so we better narrow it down to same-sex sodomy.
And Justice Thomas called that an uncommonly silly law. And now we've got to try and figure out what he meant by that. Was the moral claim that Texas was making uncommonly silly? Roger thinks yes, I think no, and John Baker thinks no. Rather, they had amended the law recently to get rid of the prohibition on bestiality, but they kept the prohibition on homosexual conduct, and that, I think, is what he was referring to as uncommonly silly. But look, the broader question here is there a line to be drawn that majorities can draw on the extent of liberty? And the different way in which Justice Thomas answers that in his dissenting opinion in Obergefell, and Justice Scalia answers that in his dissenting opinion on Obergefell, I think is significant. That you can't interpret liberty to be so amorphous that the court can make it whatever it wants. That's a positivist challenge that Scalia presents. Thomas makes a different kind of challenge, that the notion of liberty never included the forcing of some other entity to recognize your exercise of liberty. And those are two dramatically different challenges to the Obergefell majority decision. One doesn't give us much ground on which to continue to fight the next round of cases. The baker, the candlestick maker, and the butcher, right, that I call him. The other gives us a very significant ground on which to do those. And I think the one is more rooted in this kind of natural law understanding with the moral component of liberty that John Baker just talked about. And the other is rooted in a more positivist reaction to that. In that case, they both lead to them to be in dissent, but they have fairly dramatic... Now, and they join each other's opinions, so it's not as clear-cut as I'm saying, but the different modes of analysis in those two opinions, I think, are worth studying.
To get back to the question that was raised, Thomas was the only one on the court who saw what this case was really about. Unfortunately, he didn't carry it to its proper conclusion. Roberts, in his lengthy dissent, in which he cited Lochner v. New York no fewer than 16 times, railed against substantive due process. The case was really not about substantive due process. It was about equal protection. What the plaintiffs in that case were saying was this: government, if you're going to give benefits, including recognition, tax advantages and so forth, to opposite-sex couples, you can't discriminate against same-sex couples. Thomas understood that there was a perfect right of same-sex couples to go out and get married. All they had to do was find a willing preacher to do so, and they would be married, but not in the eyes of the state, and with all the benefits that the state may give to married couples that they don't give to non-married couples. And so that becomes an equal protection argument. Now, this brings us back to the fundamental point that John Baker concluded with, namely that he cites Scalia, our most important right, the right to govern ourselves, that is not the Declaration of Independence. The Declaration of Independence says our most important right is the right to be free. We turn to democracy as a means to secure that right, imperfectly though it is, because it has to involve majoritarian rule. But that majoritarian rule has to be cabined at every turn. Otherwise, we will have the tyranny that majoritarianism can bring us.
But in the structure of the Constitution, as originally drafted and added with the Bill of Rights, it is cabined at every turn.
Well, then let's get back to the Constitution.
We agree.
Okay. Next question, this gentleman up front, on the right, on my right.
Yeah, my name is Bill Klein. I'm an outsider here because I'm a retired physician, not an attorney, and a lot of this thing, especially the first session, is sort of all Greek to me, but I found this thing absolutely fascinating, mainly because I've never heard much about the question in the media or my own education. I'm fairly educated about how the Constitution and the Declaration of Independence interact, particularly with the Declaration of Independence being something that can be cited for laws and court cases and all the rest. My question is this a angels dancing on the head of a pin issue, or is this a major issue in the legal world that we just haven't heard much about, the rest of us? And if so, are there powerful arguments on both sides of it? We've heard one side here today, I think.
We haven't heard it and I'll tell you why, because we've had progressive liberals after the New Deal who love government, and therefore the Declaration flies in the face of massive government. In reaction to the Warren and Burger Court's judicial activism, and there was a fair measure of that, not as much as many conservatives think, but for more than was authorized by the Constitution, conservatives took a antagonistic view toward the court. Nowhere better captured than Alexander Bickle's The Least Dangerous Branch, in which he spoke about the counter-majoritarian problem, the problem namely that courts can counter majorities and therefore overturn statutes, and that raised serious considerations for him of legitimacy, just like it did in that comment that John just raised. And so what you've got to do is flip the presumptions and say, look, the presumption is for liberty. The burden of proof is on the part of government, not the presumption in favor of government, which is captured in the idea that statute shall be presumed to be constitutional, and therefore the burden is upon the individual to get himself out from under this statutory restraint.
Roger, I agree with you, and there should not be a presumption in favor of the constitutionality of a federal statute, because if it is a series of limited powers, the burden is on the party that has the power. It should be on the burden on the government in every case to show that the power they're exercising is actually justified by the Constitution. And at one point in Lopez, Chief Justice Rehnquist actually put that in a very short piece that very few federal district judges even picked up on, and even fewer defense attorneys picked up on it, and never went anywhere.
So, but let me pick up this. What does it matter? Are we fighting, like angels on the head of a pin, right? Historically, it mattered greatly. We probably could have avoided the Civil War if this conversation had succeeded when it was held in 1818. The introduction of Missouri. There are conflicting parts of the Constitution. Everybody concedes that textually it protects slavery. Never mentions the word slave, but it protects it. There are three different clauses that are quite clearly referring to slavery. This has become the foundation for the attack that the American founding was flawed. Contrary, by the way, to people like Martin Luther King Jr., who said it lays out a promise that we have yet to live up to, but it's all there, right? The other parts of the Constitution that were counter to that are things like the Privileged Immunities Clause, the guarantee of Republican form of government. Republicanism cannot exist unless you recognize the consent of the governed. Right? It is inherent in the nature of republicanism. So you've got these conflicting, and when Missouri comes in, it's the first state to come in that's carved out of brand new territory. Louisiana is different. I'll leave that aside for a minute. But it comes in, and we've got this fight over whether we can have slavery in Missouri. Is it instead incompatible with the guarantee of a Republican form of government? The earlier states that had come in where this was not presented were just peel-off states from states that already had slavery, where we weren't going to look behind that door. And so when Kentucky comes in and Tennessee come in and whatever, we're not going to ask that question. But when Missouri comes in, we do. And we're confronted with how do you distinguish between the principles of the Constitution and the compromises with those principles. And pure textually, you can't do it. This was the major insight that the founder of the Claremont Institute, Harry Jaffa, brought to the table. And you have to look at the Declaration to understand those principles, to be able to then decide the compromise we interpret narrowly as we can, the principle we give running room to. You can't look at that as a purely textual matter. Now, how does it play today? That's a long time ago. Well, Nevada's 90% owned by the federal government. Is that a threat to its guarantee of Republican form of government when it can't direct its own self-government within its own borders because it doesn't own 90% of the state? Right? We could see these kind of discussions come forward in those kind of litigations. The things Naomi Rao was talking about earlier, that Justice Thomas has forced us into an insight to ask these kind of questions. What does it mean to distinguish between legislative and executive powers? Well, it means that you don't get the person who's enforcing the law also be the one to make it and adjudicate it. It violates a very fundamental principle of fairness. It's in the Constitution only structurally because we got Article 1 and Article 2 and Article 3, but there's nothing that says there shall be separation of powers unless you understand the broader principle behind it. And asking it in those terms calls into question doctrines that have been in place and unquestioned for 50 years. And I think the fact that Justice Thomas in the last half dozen years has provoked that conversation, in the same way in a little concurring opinion he provoked the conversation about the Second Amendment in Prince that led to Heller and led to Mcdonnell, in the same way that he's provoked a conversation about the real meaning of the Establishment Clause. These markers have set out because he has tapped into that deeper principled understanding of the Constitution and invited us all to kind of grapple with what that means.
Let me add something as moderator. We at the Claremont Institute are actually developing a documentary about Clarence Thomas, so I've given a little thought to how the public perceives this question. And you are right that this is not often treated, and although its importance, I think, was well highlighted by John Eastman. But I agree with Roger that the sort of progressive media is one reason why it is not covered. And when Clarence Thomas was in this room, during the hearings leading up to his confirmation, he was advised not too much to discuss natural law. And that was good advice, because the idea is if you bring it up, the media will make you look bad. So even though it's important, it's often not addressed. And I think it particularly is important, as John just highlights, when fundamental issues come into play. So I think that's a good question.
If I could pick up on that, you may remember that during the Bork hearings, Bork was criticized for
Yes.
poo-pooing natural law and natural rights. By the time we got to the Thomas hearings 4 years later, it was the idea of natural rights was anathema to the very people who had criticized Bork for not raising natural
But
rights.
we forget that before the more sensational aspect of those hearings, the first phase of the hearings were Republicans on the Senate panel questioning Justice Thomas's writings on natural law and natural rights. Writings that had grown out of the seminars at EEOC.
And when we got to the question of what rights there are, Joe Biden held up Richard Epstein's Takings book on property rights and said, "You don't subscribe to anything in this book, do you? Because if you do, you're not going to get out of this hearing." So it was on the other side, it's politics up and politics down.
Well put. I think we have time for one more question, right? So does anyone want to ask the final question? All right, I guess there's a volunteer.
Hello, my name is Brett Donner. I've got a question for any of you who want to answer it. How do you believe natural law should address any conflicts between claims of negative versus positive rights? So to the extent that, for example, a right to a jury trial can be construed as a positive right, where do you draw the line between what's a permissible positive claim versus what?
You're thinking like a lawyer, drawing lines. The relationship between law and philosophy, which should be covered in a jurisprudence class, which unfortunately most lawyers don't get anymore, it's much more involved than that. It's not a question of line drawing. There is often a difficulty in deciding, and different people will have different views, on whether a particular statute is the declaration in positive writing of the natural law, or whether it is purely positivistic. And that is really in the eye of the beholder in many ways. And you have to go through these discussions. There is no, lawyer answer to that question. And if you want to see, just go back to the old common law discussions about malum in se and malum prohibitum. That's really what it's about there, and lawyers and judges have always had difficulty in that because, unlike the founding, very few of them have any philosophic training.
But I've got a different answer to that, because I do think that in many cases there are clear lines to be drawn that are required to be drawn if you properly understand the natural law argument. So what are the modern versions of the positive rights? I've got a positive right to housing. I've got a positive right to a free education. I've got a positive right to health care, right? These are the principal ones. Well, the Southern slave owner said, I have a positive right to my property. Modernly, we say I have a positive right to choose to abort the fetus in my womb, if I'm a woman, right? These are all versions of a positive rights claim. Right? And the response to that, it seems to me, the insufficient response is none of those are specified in the text, and therefore they're not rights. Like I said earlier, I think that violates our DNA. The question is, are they fundamental rights? And Lincoln, in response to the slave owner question of I have a positive right to my property that's protected by the Constitution, he said, well, that's true unless the black man is also a human being or is different than a hog. Because if he's not different than a hog, then your claim of positive right is destroying his claim of unalienable right. Right? And so we have to look at the nature of the claim. What is a claim of free education? It means that somebody else is going to be compelled to pay for it. And that therefore destroys the right for them to keep the product of their own labor. That's where the fundamental right is. And any claim of positive right that destroys it cannot possibly be reconciled as a claim of right. And it's fighting it on those terms, that this is not a right because it destroys the nature or notion of rights, I think is a more likely success to push back this rights revolution, that everything is a right, these positive rights revolution, than we ever read. You've got to question what the nature of the right is. And if it's a claim that destroys rights of others, it can't possibly be an unalienable right.
I think it's simpler than that. I think the founding generation would have said that if you claim a right that goes against moral obligation, it's not a right, period.
The question of line drawing is inescapable. At common law, you had to draw lines constantly where one person's right ends and the next person's rights begins.
Property
as in
law.
Such areas as nuisance, risk, remedies, and enforcement. And in fact, the jury trial is a good example of a right that is part and parcel of the enforcement rights that are positive law under the fundamental power of government to secure our rights, most of which power rests with the states under our Constitution as the police power. There is no general federal police power. With respect to the larger question that you've asked, that John Eastman just addressed, the idea that there is, to quote the Article 24 of the UN Declaration of Human Rights, periodic holidays with pay, that kind of right is not part and parcel of the core function of government as securing our rights. It is available only if it is created through consent as a matter of legislative or positive law. Fortunately, the Constitution did not recognize such rights. We have, to our detriment, created them all over the place. They are called redistributive rights. And they take two forms: under the taxing power, material redistribution, and under the regulatory power, the prohibition of doing things that are rightfully to be done, and the requirement of things that are by right not forced upon us for the benefit of other people. And with that, we have created Leviathan, under which we are all suffocating today.
You want to make a
Yeah, just one note on, because I didn't really respond to Michael's question. This just occurred to me right now. I recall a conversation when some of us who are acquainted with Harry Jaffa, our teacher of so many of us, we were critical of him in the presence of Justice Thomas, and he was shocked. He was somewhat scandalized, and he said, look, you're not appreciating what he's saying. And that's a bad paraphrase, but it was one revolutionary praising another, and he saw what that involved.
Well, that's a nice ending. It's always appropriate. Thank you. Thank you to all the panel, and thank you also to the Federalist Society for partnering on the event. I hope you're all here again for the 50th anniversary of Clarence Thomas's Jurisprudence. I have one point of business. We have to exit in the Dirksen building, which is connected to this building because the building exits here are closed. I think people will be directing you as you exit, and there'll be people guiding you along the way. So it should be painless and simple, but who knows? I feel we've just scratched the surface of a very complex subject, and thank you all for joining me. Thank you.